Malfi.
Good morning, Justice Marshall. Good morning, members of the court. My name is Elizabeth Falvey, and I'm here today representing the respondent in a bar discipline case, Stephen Hrones. The issues involved in this appeal center around Mr. Hrones' relationship with a paralegal who had gone to law school but who had failed the bar on numerous occasions, named Lionel Porter. And there are some minor issues about his IOLTA account, which I don't think are really central to the issue here. I believe the reason we're here on report from a single justice is because the law in the Commonwealth is very unclear with respect to the distinction between negligent supervision of a paralegal working in a law office and the unauthorized practice of law by that paralegal.
Do you claim, as I'm just trying to make sure I understand this in my own mind, that there was no unauthorized practice of law?
Not only do I claim that, Your Honor, but two members of the hearing committee found that Bar Counsel had not proved that there was practice of law by Mr. Porter.
I take it that you agree that the failure to supervise in certain circumstances, in particular an intent to create an environment in which a paralegal can reasonably expect to undertake actions that constitute the unauthorized practice of law, can indeed be the basis for such a finding that it was an assist to engage in the unauthorized practice of law.
Absolutely, Your Honor, but it's the respondent's position that the assist is an important proof and that the assist requires some sort of either overt affirmative act, holding out as a lawyer, something more than simple negligence in failing to supervise a paralegal.
How about willful blindness? I mean, the red flags were coming in left and right.
Well, I don't agree that that's what the committee found, and I don't agree that that necessarily rises to the level of assisting, particularly here where the hearing committee did not find that Bar Counsel had proved that Porter engaged in the practice of law.
But the board read the same, right?
Right, but the hearing committee heard the evidence, made that as a factual finding, and it's Bar Counsel's burden to prove. This is a particular circumstance, and in fact, even though respondent doesn't have the burden, respondent called a former commissioner of the MCAD to testify, and his testimony was that Porter in particular and other paralegals in general appear regularly up at the MCAD, that they assist clients there, that their participation is to a large degree encouraged because otherwise the MCAD would have a lot of unrepresented people.
But your client supposedly, from what I gather from the briefs, didn't know anything about practice at the MCAD, so how would he have even known what the practice of the MCAD was?
Well, actually, because the hearing committee found as a fact that when the relationship with Porter started, respondent and Porter discussed what the scope of his activities would be. Mr. Hrones asked respondent about that, or Porter about that. Porter described his previous practice and showed Mr. Hrones a statute which they looked at and decided permitted Porter to do what he proposed to do. And the hearing committee accepted as credible that testimony.
Let me ask you this. In the board's decision, page 12, I think it's page 124 of the appendix, the board says, Porter marketed services the respondent knew would be performed as part of an employment discrimination practice Porter alone would manage without supervision in the respondent's office. Do you agree that that's a finding in this case?
Yes.
Porter exercised sole discretion in deciding which cases to accept. Do you agree?
In large part, yes.
He personally entered to and signed fee agreements. He set and collected fees. He filed complaints with the MCAD and EEOC, and he propounded and responded to discovery. Is that agreed?
Not completely, Your Honor. There was some element of supervision, as the hearing committee found. Mr. Hrones instructed Porter at the beginning of the relationship on the use of fee agreements. The fee agreements were to be signed in the name of the firm, and all retainers and fees received from the clients were to be deposited in the firm's operating account. So I don't agree that Porter was out there on his own. There's plenty of evidence that Mr. Hrones made a number of efforts, such as controlling the use of fee agreements, such as...
Well, who set the fee? Who set the fees and collected the fees? That was Porter.
It was a standard fee agreement. The fees came to the office by...
A standard fee agreement, so much pursuit? I mean, I don't understand what a standard fee agreement is in a discrimination
I believe they were
case.
mostly contingent fee agreements.
Okay.
What about after the MCAD letter of suspension in September '03?
I think that underscores, Your Honor, respondent's good faith belief that he was doing nothing improper, because what respondent did with that letter was first to call the MCID and ask for a hearing, call the general counsel of the MCAD, ask for a hearing, collect members of the discrimination bar and ask for their assistance, and finally, he sent that letter to the Office of Bar Counsel and asked them to investigate. I would suggest, Your Honor, that that is the very last thing that a lawyer who had any questions about his conduct would do. And that's further evidence of the fact that, albeit he may have been mistaken, Mr. Hrones had a good faith belief that what he was doing was permitted.
And then he failed to withdraw with regard to any of those 40 clients in violation of the order of the MCAD.
Well, he did, and the hearing committee addressed that. This was not an easy situation. These were not clients that other lawyers were lining up to take or who had ready access to representation other places. If he had withdrawn, these clients would have been without representation. And in fact, later when Porter was fired and he made effort to get representation for what the hearing committee described as, I think, small value, questionable merit cases, he ended up in trouble for asking other lawyers to take
Right, but during the
them.
period after he was suspended, when he no longer could represent these individuals, and that before he was fired, which, by the way, was only for stiffing Mr. Hrones, not because of his incompetence as a paralegal, he abandoned those clients.
Well, if
Did he not?
if he'd withdrawn, he would have abandoned them.
But at least then they'd know that they're on their own.
He had no good choice, and I think the hearing committee found that. I don't argue that he was not negligent. He admitted before the hearing committee, he admitted before the board, he admits here that he was negligent, that he did not properly supervise Mr. Porter.
What do you say is the right disposition of this case?
I believe, Your Honor, and Mr. Hrones has consistently maintained that he should have a 3-month suspension and that should be suspended. This is not the kind of conduct which is going to be repeated.
Is Bar Counsel seeking, well, I suppose I should ask Bar Counsel whether they're seeking a year and a day or 2 years.
Well, up until, I guess this brief was filed, it's always been 2 years
That's what
relying
you
on
said in your
Jackman.
brief, yeah.
Yeah, and for the first time in the brief, I guess they're now willing to accept the board's recommendation of a year and a day. I still argue that that's excessive given the absence of any finding of intentional misrepresentation, dishonesty. If one looks at the breadth of this Court's decisions and the board decisions, it's very difficult to receive a suspension of a year and a day without telling a lie to somebody or
Well, what do you
stealing
say
a
about the
client's
letter
money.
that was given to, the letter that he endorsed under his name, say that it's important to have knowledgeable and experienced legal representation, that the persons at the firm have several years' experience handling discrimination complaints?
The hearing committee found that that was not misleading, and Bar
But
Counsel
the board
presented...
found that to be
But the hearing
misrepresentation.
committee, as the fact finder, found it was not misleading, and Bar Counsel presented no evidence from any
Okay,
client...
how can it not be misleading?
Because it says persons have experience.
Says-
Again,
But members of the firm, but wasn't it a finding that there was nobody in the firm other than Mr. Porter who'd ever done anything with the
okay, so
MCAD?
there's an S there, but I think the hearing committee overall found that that was not misleading, and there was no evidence that clients came to their firm because of that.
Which person at the firm did have experience in this area? So the person, so is not, does that not then reflect that he was putting him out as somebody who was authorized to practice law?
Right, which Bar Counsel did not prove he was, no, I apologize. He was putting him out as someone who was permitted to practice at the MCAD, which the committee found Hrones in good faith believed that he did, and which the hearing committee found Bar Counsel had not proved was incorrect.
Okay, but the letter says, essentially, we at the firm have several years' experience. The only person who had experience was a person not authorized to practice law,
Right,
who
and
was
so-
then who then the clients were assigned to and was on his own with no guidance as to any legal matter.
I understand, but if that interpretation is assuming that Porter was not authorized to do what he did.
Well, let me go back to the findings on that page. I sort of worked my way down. The last one is, without consulting with the respondent, Porter advised the clients about their legal rights, settled cases, removed them to state and federal courts, and performed all or virtually all other legal work on the cases. That's not the practice of law?
The committee found that it was not proved that he did things he was not permitted to do. I mean, there are administrative hearings where paralegals are permitted to show up and to represent clients. In fact, the MCID has a specific provision that allows paralegals, non-lawyers, working for various legal services organizations and volunteer organizations like the NAACP to show up at the MCAD and do exactly what Porter did. And that's how Porter got his start at the MCAD in the first place.
But he wasn't any longer doing that.
I understand, but the MCAD former commissioner testified that that statute was
Mr. Walker?
interpreted. I'm sorry?
Mr. Walker?
That's right. I knew it was Charles something, and I apologize. That statute was interpreted, our regulation was interpreted very loosely, and that as long as there was some general affiliation with a volunteer organization, even if the person was with a private firm.
Isn't it up to us to decide what the practice of law is? I mean, the MCAD might decide, well, none of these things over here we view to be the practice of law. That's binding on us in some way?
Well, but if
filing suits, giving legal advice to people, I mean, if that's not the practice of law, I'm quite confused about what the practice of law is.
That may be a different issue, Your Honor, but if a lawyer allows a paralegal to do something at an agency which is permitted by that agency, I don't believe that should be a disciplinary violation because he in good faith believes that the paralegal is doing something which in fact the agency permits. And that's really what's happening.
Do they currently do that now?
I'm not clear on that, and actually there are a couple of regulations included in the appendix to Bar Counsel's brief which were not before the hearing committee or the board. One of them is dated 2007, which was long after this, and I don't think it's relevant to what Mr. Hrones believed and what the situation was at the time.
What do you say, just looking at this issue of unauthorized practice of law and the role of Mr. Hrones, what is the difference between his conduct and Jackman?
I think it's an enormous difference, Your Honor, in two respects. Mr. Jackman gave the paralegal, set him up in a separate office, and actually gave him access to the operating account and the IOLTA accounts. The paralegal had signing authority. He ran a completely separate, financially independent practice and stole money from the clients. Now, the reason I think that's so important is because there's no question if Mr. Jackman did what that paralegal did, he would have been suspended indefinitely or disbarred. And the board, I was on the board at that time, we recommended that he should be indefinitely suspended. And the court said, no, this is a 2-year suspension. He's not liable as a principal, even though he gave the paralegal access to the IOLTA account, which is, in my mind, the worst thing you can do as a lawyer. And in this case, if Mr. Hrones had handled these cases on his own and made a mess of them, we would have had probably a Cain situation where it would be a 6-month suspension for repeated instances of neglect. And yet, here, the idea is that he should suffer a greater sanction for the conduct of his paralegal than he would have if he'd done the actions himself. And that's exactly the opposite of what Jackman says is supposed to happen. So I don't think this is a Jackman situation at all, and I think that Jackman tells us that a year and a day is more than would be appropriate under these circumstances.
Before you sit down, do we know where Mr. Porter is? What's up with him?
As far as I know, nobody has ever known where
He's
Mr.
vanished.
Porter is. Mr. Walker testified that he had seen him in the years after the severance of his relationship with Mr. Hrones, and before the hearing he'd run into him up at the courts a couple of times. But the answer is nobody really has a good idea where he is.
Thank you,
Thank you.
Ms. Mulvey. Ms. Weisberg?
Good morning, Chief Justice, Justices, may it please the Court. In 2001, Stephen Hrones set up Lionel Porter in practice, gave him office space.
Well, be careful when you say in
overhead.
practice. I mean, we're trying to separate two very important concepts here. So when you say in practice, what do you mean?
I mean that Stephen Hrones gave Mr. Porter an office and overhead in the use of his law license, a solicitation letter over the respondent's own name inviting clients into the firm so that Lionel Porter could conduct what the respondent himself called and what the hearing committee and the board found was an independent discrimination practice with no supervision or virtually no supervision by any lawyer. And indeed,
Well, that's
no
negligent supervision of a paralegal.
beyond that, Your Honor, I would suggest, because the intention was that Mr. Hrones would not be supervised. Mr. Hrones was not a paralegal in the firm. I think it's important to remember he was an independent contractor.
You mean Mr. Porter?
Mr. Porter.
Mr. Porter, excuse me, was never a paralegal in the firm. He wasn't hired, and he actually wasn't fired. He was not
I
a
thought he was
paralegal.
listed on the letterhead as a paralegal.
He was held out as a paralegal employee of the firm, and that's one of the problems. The problem was he was held out to the world as a paralegal employee of Mr. Hrones, based on which the public would reasonably conclude that he was under Mr. Hrones' supervision and doing what paralegals do. In fact, he was an independent contractor paying essentially Stephen Hrones a fee for using his office and his law license to conduct a practice at the MCAD. That's a very big difference, I would suggest to you.
Well, the using his office is not a big difference because there are lots of paralegals who use people's offices. So far, it's the using his license.
Using his license and paying a fee for it, I think, is a big difference. I'm not aware of independently practicing paralegals using law offices as a home base for their practices in the Commonwealth. But that's not what happened here. The arrangement here was that Mr. Porter would work in this office, he would be on the letterhead, and in fact there's a finding that Mr. Hrones, as he testified, understood that although people would assume he was a paralegal within the firm, Porter was actually conducting his own practice. When I call this an independent practice, or Porter's business, I am only quoting the respondent himself, as you will see throughout the findings. In fact, there's a very long footnote in the findings where many, but not all of the instances in which the respondent characterized this as Porter's practice, Porter's
But it
business,
could be
Porter's
Porter's
operation.
paralegal practice, Porter's paralegal practice, Porter's paralegal practice.
You've asked, let me just preface briefly and say that I think trying to create a dichotomy between unauthorized practice on the one hand and failure to supervise on the other is neither necessary nor appropriate. They're not mutually exclusive, and in fact, in Jackman, both were found. Unauthorized failure to supervise and unauthorized practice.
Yeah, there can be
both.
circumstances, and Ms. Mulvey said in certain circumstances, negligent supervision of a paralegal can morph into unauthorized practice, and she's simply saying, on the record of this case and the findings of this case, that did not occur.
That's true.
So it's not helpful to me, Ms. Weisberg, if you sort of roll it in by saying practice, practice, practice. That's all I'm saying.
Well, let me point out some more indicia that, if that would be helpful, by which.
Well, first, do you recognize that there is a difference, at least when it comes to discipline, between the negligent supervision of a paralegal and assisting in the unauthorized practice of law?
I think there is a distinction, but I'm not sure it makes a necessary difference in the outcome of this case.
First, my question was, is there a difference? The answer to that question is yes.
There is a difference.
Okay.
There are two different disciplinary violations, but I'm suggesting that the essential issue here in looking at disposition is the nature and flagrant and uncorrected extent of the misconduct.
May I
case.
ask you this? How do you respond to Mr. Porter's testimony that he was not a paralegal? He was not a paralegal. 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 He was not a par Mr. Walker's testimony that the MCAD allowed not only Mr. Porter but a lot of other people who were not lawyers to appear there regularly.
Mr. Walker actually testified, and he was testifying about a time that ended before Lionel Porter began to work for Stephen Hrones. Mr. Walker was testifying about his own tenure, that there was a period in which people were welcome to come in and assist complainants. That's true. He also testified that when paralegals or non-lawyers came in, they typically assisted clients and accompanied them at the informal stages of an investigation. And in fact, there's a specific regulation that I cite in my brief that allows a claimant, that allowed a claimant and still allows a claimant to be accompanied to an informal investigative conference by his or her attorney or other representative. Mr. Walker also testified that he had known Lionel Porter when Lionel Porter was with the NAACP, which is an organization expressly recognized by the MCAD regulations as competent to bring complaints before the commission. I don't think you'll find any testimony in the transcripts by Mr. Walker or anyone else that anyone loosely affiliated with a private firm or a legal services organization could come and do this. This was a specific regulation. But Mr. Walker also testified that hearings on probable cause, interrogatories, depositions, and public hearings at the commission were to be handled by the attorney. When Mr. Walker testified that when he saw Lionel Porter, it was at these informal conferences. It's also important to remember that Lionel Porter didn't practice as Lionel Porter. We're not here to decide whether Lionel Porter, acting independently, was authorized by MCAD to come in and be a representative, or whether if MCAD authorized that was appropriate. Lionel Porter was there as Stephen Hrones. Stephen Hrones testified, and the board expressly found that the respondent knew that Porter could only appear at MCAD pursuant to his own appearance.
Well, I have a question about that. After the MCAD informed the respondent by the letter of November 19th, 2003, that Porter and his firm were suspended from practice before the MCAD for 1 year, how could the 40 MCAD cases continue to have been processed at the MCAD?
I don't have an answer for that. I know about one case, the Bernie Smith case, and I think it's count 4.
But I mean, who was appearing for them?
Nobody. That's the problem. And well, I can tell you what happened in the one case we know about. Bernie Smith, she was at the pre-probable cause stage. Lionel Porter handled it, didn't do a good job on it. The suspension order entered. The respondent was ordered to notify these clients and withdraw his appearances. He did neither. And MCAD subsequently issued a notice and issued other notices to Bernie Smith, but sent them in care of the Hrones Law Office, and you'll see them in the record. Well, you would see them in the record. So the answer is that's what MCAD did.
So the cases apparently went forward with notice of hearings going to the office that they had already suspended.
Yes, and with no one in the office doing anything about it, at least in the Bernie Smith
Well,
case.
That one was dismissed, wasn't it?
That was dismissed, and nobody told Bernie Smith until, I think, 2005, when she called MCAD herself.
One would think that Bar Counsel would have investigated that, because if notices went to the office, that would be further evidence that Mr. Hrones was continuing to practice law after knowing that Porter had been suspended.
We had the evidence in the Smith case that the notice went to that office, and we had the evidence that the respondent and Porter didn't tell Bernie Smith or anyone else by Mr. Hrones' testimony.
When did you start investigating? Early 2004?
2004, yes.
And let me ask you this. I'm a little confused about this letter sent by Mr. Hrones to Bar Counsel or to the board back in November of 2003. What did that trigger? Did that trigger all of this? I mean, what triggered what here?
The demand, Justice Cordy, was that the Board of Bar Overseers investigate MCAD for suspending him and do something about it.
And was that what triggered the board essentially looking at Mr. Porter?
That triggered us to send a letter to Mr. Hrones saying we've had these reports of misconduct, but that was directed at Mr. Hrones' conduct. Mr. Hrones, when he was suspended, his activities were directed at protecting his rights and Lionel Porter's rights.
No, but doesn't that letter suggest that Mr. Hrones thought that what was going on was perfectly proper and and that, if anything, there was abuse going on by the state agency? I mean, isn't that a little inconsistent with knowingly assisting in the unauthorized practice of law?
I can't speak to, and it's not in the record, what precisely the MCAD relied upon in accusing Mr. Hrones of, I think the words were possibly assisting or maybe assisting in the unauthorized practice. I can't speak to what was in the agency's brain.
No, I'm saying his conduct in essentially bringing that to the attention of the board seems to be very consistent with him having no sense that what was going on in his own office was illegal or unauthorized or inappropriate.
Well, I think that one of the justices mentioned the term willful blindness. I would suggest this is an insight question. Bar counsel's position is and remains that in specific intent, it's almost a criminal standard described by the respondent, is not an element of the violation of unauthorized practice. The court didn't find it in Jackman. It's not in the rule. We don't have a case that says in this jurisdiction that you have to specifically intend to help someone engage in criminal conduct. Unauthorized practice is criminal.
But there's got to be some sort of intent. I mean, if he honestly believed that what Mr. Porter was doing as a paralegal under his bannerhead was legal and appropriate before the MCAD, does that make no difference at all?
I think it goes to disposition. I'm not suggesting it makes we're not talking about a mistake of fact.
Well, there may be negligent supervision regardless of whether he thought it was what he was doing was proper.
And there may be negligent assisting as opposed to intentional assisting. I think the Kingsley case that was relied upon or cited by the respondent in his brief talks about the importance of determining state of mind for purposes of disposition. But this wasn't just passive assistance or a mistake of fact. It's not that Stephen Hrones thought that Porter had really passed the bar when he hadn't. It's not simply that he sat around and did nothing. He put the tools in Mr. Porter's hands and he let him go out and do it. And it didn't end at the MCAD. I think that's very important to remember.
Yeah, but wasn't that circumstance of allowing him to do these things before the MCAD, wasn't it with the understanding that it was permissible before the MCAD?
It was with the understanding, based on a regulation, supposedly, that, by the way, has never been identified, that Porter could appear.
What do you mean it's never been identified?
Mr. Hrones testified at the hearing that he looked at some regulation or statute that led him to believe that Porter could do this.
Well, didn't the people at the MCAD know that Porter was not a lawyer?
I assume that at least some of them did, except that Porter was presenting and signing everything in Stephen Hrones' name. Everything that was filed pursuant to an appearance by Stephen Hrones as counsel of record.
So they treated all the clients that he brought in as people who were assisted by a lawyer, right?
Yes, and they were in the attorney-assisted unit where you had to be a lawyer and where you got extra discovery rights.
So when they talked to Porter, did they address him as Mr. Hrones?
I don't believe so, but if Lionel Porter came in and filed a pleading that had Stephen Hrones' name on it.
But if they were addressing him as Mr. Porter, they would have had to have known that he wasn't Hrones.
Well, if they were addressing him as Mr. Porter at an informal conference, for example, there wouldn't have been an issue because, as Mr. Walker testified and as the regulations say, non-lawyers could assist at informal conferences. There was only one case we know of that got to the point of a public hearing where the statute is clear. There has to be a lawyer. And at that point, MCAD said to Porter, you can't do this hearing because you're not a lawyer. And Mr. Hrones knew that. This was in the Murray case, and it was in May of 2003. It was several months before the suspension. The agency said to Porter, you can't do this upcoming public hearing. Only the counsel can do it. And Mr. Hrones knew that, and he didn't show up for the hearing, and he didn't do anything about it himself. He sent Porter back to try to get it continued. That was unsuccessful. The case was lost. Then he and by the way, Mr. Hrones was sanctioned for Mr. Porter's activities in this case. Mr. Hrones didn't pay it. This was all in the months leading up to the
Ms.
MCAD
Weisberg, let me ask you this. I'm trying to figure out, why the hearing committee goes off in one direction and the board in another to some extent. If you look at the paragraph on page 18 of the hearing committees where they're sort of dealing with, in essence, Mr. Hrones's defense. He attempted to contain Porter's conduct within what he understood were the proper boundaries. Do you agree?
No.
Okay.
I don't, well, I agree that that's what it says, but I don't agree that that is an accurate description of what Mr. Hrones did.
That's a finding?
Excuse me?
That's a finding, correct? So you say that that's an erroneous finding. It's under the findings. I think it's still under the findings.
It is under the findings, and I'm not disagreeing that, well, let me say that to the extent that it's a finding rather than a characterization, I'm suggesting that the attempt was inadequate and
No, the attempt may have been inadequate. It may have been negligent supervision, but
and doesn't fully describe the problem, because I'd like to, if we could.
well, let me just keep going, because we're running out of time. He listed Porter on the firm letterhead. He instructed his staff to correct anyone who thought Porter was a lawyer. He required Porter to use his approved contingency fee agreement. He required Porter to call on an attorney in the firm for help in cases removed from an administrative agency to a court, and he reprimanded Porter for conduct straying beyond what he perceived to be its proper limits. It seems to me that that's a sort of core piece about why they're finding.
I understand that those are the specifics that underlie this good faith belief, but I would suggest that they address only the administrative part of Lionel Porter's work. What Mr. Hrones himself testified to as his assistance, for example, after a case was removed from the court, and this is at, I think, page 16 of Mr. Hrones's brief, he said he was available to offer assistance to Mr. Porter on court cases. I would suggest that turns the issue on its head, and I would urge you to look at the case I've cited in my brief, the Agbasi case, and what Mr. Porter wrote when he tried to get the dismissal in the Agbasi case removed. What he said, among other things, and this is at page 252 of the record, was, it is manifestly clear that this is a case of neglect and inadvertence by Mr. Porter acting on behalf of the plaintiff. This is a brief to the U.S. District Court and not the plaintiff herself. First, after the complaint was filed in this court, Mr. Porter of necessity turned his attention to his demanding caseload at the MCAD over which he had primary oversight. And then skipping further, Mr. Porter had direct responsibility for marketing, case intake and evaluation, drafting pleadings, interacting with counsel, representation at conciliation conferences, and overall case management of approximately 40 to 50 cases. And then I'm skipping these.
Ms. Weisberg, I hate to interrupt you, but we're so long over the time, and this is in your brief.
Yes, it is, and I appreciate the Court's indulgence.
Okay. Thank you, Ms. Weisberg.
Okay.